TNA District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge
You may. We don't have either defendant out here, but the court does call the case of Jamal Jones and Omar Smith, People versus.
Peter Childers appearing on behalf of the people, Your Honor.
Outdoor Waters is prosecutor on behalf of the people.
Randall Upshaw, my apologies for my mistake on behalf of Mr. Jones.
And Judge Colin Daniels on behalf of Mr. Omar Smith. I am stating if the attorney of record Neil Rockine in this matter.
I will bring the defendants in. Somebody's going to need to explain to me why I'm almost 2 hours after start time on this case.
I can start. I just want to say, Judge, you know, I received a phone call that the parties, attorney and Mr. Rockine, I informed them, well, I'm ready, but if the judge doesn't want to do two bifurcated cases and the attorney is not prepared because he didn't have discovery, I'm not going to oppose it. But if it's so if you got my permission to sign the order, and that's what my order. So I thought when I gave permission to sign the order, because and I'm not throwing any stones at Mr. Rockine, he's a brand new attorney, and I've just called myself giving respect to the parties and said I leave it to the powers that be. Then I went to had a hearing up in St. Joseph this morning, and I found out on the way back, and I apologize because there's a blizzard up that way. But I didn't know until I got halfway in the middle that you didn't sign the order when someone called me, because I thought it was adjourned.
Anybody else?
Yeah, Judge. So I guess I can weigh in on that as well. So we just got retained. Our office was just brought in 10 days ago. We just finished downloading all this discovery actually yesterday. I had talked to the prosecutor's office to let them know that we were going to be requesting for. I think we actually had emails back and forth with your staff that was, and we were told that it was going to have to go on the record, any kind of adjournment request. So I was.
Well, I think it was made clear I wasn't necessarily adjourning. I mean, and also the bigger problem, and I don't even know how the email chain started, but I don't even think Mr. Upshaw was on that initial email chain.
No, I don't think he was. I think that's accurate, Judge.
Go ahead. I'm sorry.
No, that's okay, Judge. So, I mean, I think just given the short amount of time, obviously our plan was to come in here and ask the court for an adjournment. We weren't presuming one, but given the short amount of time, we were hopeful that the court would be understanding with it. In addition, just so the court's aware, Mr. Rockine, who is the one that filed this appearance and is going to be handling the matter, has been unfortunately stuck in a much longer murder trial than he had anticipated. So he's been in a murder trial in Oakland County in front of Judge Cunningham since January 12th. We did not anticipate it going this long. I just found out a half an hour before the court came out that the jury had come back with a verdict. So we now have a verdict in that case, but Mr. Rockine is still stuck over in Oakland County. So I guess that's kind of the situation.
The people.
And Your Honor, for remarkably, Mr. Overwater and I were in front of Judge Conlon last Wednesday when Joe Hall from Mike Vincent's office let us know that they had been retained out with respect to Mr. Smith. I called Mr. Daniels that afternoon once I heard that it was Mr. Rockine's office and explained to him, because Mr. Daniels obviously said our position was asked for the examination. Are you agreeing to that? And if memory serves me right, my conversation, something effective, I'm not going to object because I understand the position you're in. However, we had two defendants and in the people's position, strong preference to hold one examination, not two. So I'm not in a position to, offer a stipulation, not saying the court would accept it, but that was the people's position. And then Mr. Overwater spoke with Mr. Upshaw, I believe it was either Thursday or Friday of last week, to let Mr. Upshaw know that what the status of the co-defendant was, and to get what input he would have regarding that adjournment. But the people have maintained, that there is a possibility that this court may decide that while one defendant's exam may be adjourned, the other defendant is sitting in custody and that exam may proceed. So we've been in continuous discussion with Detective McDonough about witness availability in the event that an examination is held this afternoon.
And I also made a stipulation regarding one witness, this female witness who made a brief statement. I can't think of her name, the council knows her name, and I informed them, hey, I can go, and if you can't find the witness that I want, I'll just stipulate, we made a stipulation for exam purposes that we read the tape that we go forward, the 5-minute video of her statement of what she saw. Just like I said, I'm just here, I'm doing whatever the court, whatever he wants to do, I'm ready either way.
And so as I sit here right now, if I said we're going, you're not prepared to go.
No, Judge.
If I didn't agree, and unless you believe that there was something that came from my office that said this was to be adjourned, I don't know why I don't have the attorney of record or the one that's going to handle it here now.
The only thing I can fall back on, Judge, is what I kind of already explained to the court. I don't have a better explanation than that, Judge.
So the court set aside time, and your office just thought we were kidding in terms of the time.
No, Judge.
I've got these 2 people in custody, and then somehow or another, people are led to believe, and I've known Mr. Upshaw for a while, and I think if something had to be intimated to him that there was an adjournment, otherwise he would have been here. There's not a doubt in my mind about that. And I have to say that must have come from the people in some way, because he would have been here. And now I'm sitting here today, 2 hours after when I was supposed to start, and can't do anything. How many witnesses do you have here?
Right now, the only witness we have here is Detective McDonough.
Where are the other witnesses?
They're on standby or.
Yeah.
Meanwhile, these 2 individuals are in custody on murder charges, and this is the best we can do, folks. Really? How long is it going to take you or your office to be ready to go? And I'm not giving you much time.
I understand, Judge. I mean, I will preface this with, I don't know how much discovery there is. I know that it took my office 3 days to download it all, to go through it all and get it all downloaded.
Counsel, then go out, call the attorney that's going to handle this case, find out how much time he needs, because I'm going to set this, and then everybody's going to be here. Everybody's going to be ready to go. These 2 gentlemen are going to have their exam. Am I clear?
Clear, Judge.
Court is standing in recess. You let us know when you.
All rise. Michigan is now back in session. The honorable judge.
You may be seated. Let me just say I was a bit remiss in calling these cases. We're going to need to defend it, so for the attorney. Bit remiss in not acknowledging that seated with me on the bench is my newest colleague, or our newest colleague here in Washington County, Judge Garwood out of the 15th District Court. So he's also presiding with me today. Here, I am. They're bringing that one. Got it. Court does call the cases of the people of the state of Michigan versus Omar Ernest Smith and the people of the state of Michigan versus Jamal O'Neill Owen, or O'Neill Jones.
On behalf of people.
Hearing on behalf of the people.
Colin Daniels on behalf of Mr. Smith.
And Randall Upshaw on behalf of Mr. Jones.
And the defendants at this time are present. I have indicated to council that my staff had provided dates. I was not going out as long as some council wish for the court to go. I will go out 2 weeks. These gentlemen are entitled to have their preliminary examination timely when things are ready. It was set and I set aside the time. I will adjourn. My understanding is the parties have selected the dates that were available for the court. February 6, 2026 at 1 p.m.
Excuse me, I was told noon.
Yeah, I was told noon too.
I did say
Okay, then we'll set it at noon. The way we're going, the way you guys want to show up till 1 anyway. No, I'm kidding. All right. Is that correct?
That's fine.
Everybody?
Thank you.
All right.
That's correct, Judge.
All right. Bond will continue as denied both of these cases. Thank you.
Thank you.
Thank you, Judge.